Tēnā koutou katoa, tēnā tātou I roto I te whoro. Nō reira, tēnā koutou. I've just welcomed you in Maori, as it's Maori Language Week here in New Zealand, all of our attendees across Australia and New Zealand. This is the latest in the BFSLA's series of topical webinars. And today we're going to be talking about the impact of climate change and in particular activist claims for banking and financial services lawyers. I'm delighted to have here as our guest today, Sarah Barker. Sarah Barker is a special counsel and head of climate risk governance at MinterEllison's team in Melbourne. She has an august resume. Amongst other things, she's Australia's representative on the cross-jurisdictional Commonwealth Climate and Law Initiative. She's also an academic visitor at Oxford University's Smith School and teaches sustainability and governance for Cambridge University. She's advised the Bank of England Prudential Regulatory Authority on climate risks for the insurance sector. And she was also the instructing solicitor on the briefs given to Mr. Noel Hutley, SC, who is the leading silk in Australia, who's written some very influential opinions on the implications of climate risks for directors' duties. So welcome, Sarah. It's great to have you here with us today. Now, we live in extraordinary times. In the various cities that are being linked up through this webinar, I know we're coping with the COVID pandemic. Some of us are in different places. Some of us are from home. We have family in the background with pets. Others are working from the office. Despite all of that, I think that climate change remains the defining risk of our age, including for bankers and public issuers. Now, when we're discussing this, I'm going to take for granted that most of the audience are aware of Mark Carney, the former Bank of England's taxonomy of climate risk, and understand that it includes physical impacts, the transitional and economic impacts, and also the liability issues that can arise. And it's against that background that I want to start, Sarah, to ask you a little bit about this recently filed case in Australia, O'Donnell against the Commonwealth of Australia. What's that involved?
Thank you, Lloyd, and apologies, we're in week 6 of hard lockdown here in Melbourne, so the sign I have plastered on my office door that says, please do not disturb mum, she's on an important work call, seems to have lost its impact. Thank you, Lloyd. Before I talk about O'Donnell, just to acknowledge that I'm coming to you from the traditional lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past, present and emerging. So the O'Donnell case. This was a claim that was filed in late July by a retail investor in exchange-traded bonds of the Australian Commonwealth Government. And the allegation is essentially that the information statements issued to investors in relation to Commonwealth sovereign bonds are misleading on the basis that the information statements do not disclose the risks associated with climate change, both to the Commonwealth in general and to the investability of the bonds in particular. So that's making the allegation under our ASIC Act, Section 12DA of our ASIC Act, which is the general provision governing misleading disclosure for financial products and services in Australia. It's a really interesting claim for a number of reasons. First of all, in addition to the misleading disclosure claim against the government or the Commonwealth itself, the claim also is made against 2 individual officers of the Commonwealth. So the Secretary of the Treasury and the CEO of the Australian Office of Financial Management. That's and there's my Maltese joining us as well. who are the authorised officers of the Commonwealth for the purposes of issuing these bonds. And there the claim is made that they have acted in contravention of their duty of due care and diligence. So as Commonwealth officers under our Public Government Performance Accountability Act, Commonwealth officers have similar duties to those under the Corporations Act and the Companies Act there in New Zealand in relation to exercising due care and diligence in the discharge of their duties. And so the claim is made there that essentially by allowing the Commonwealth to issue investor statements that were misleading for the purposes of the ASIC Act, that these officers have breached their duty of due care and diligence. Also interesting because it's a claim made in relation to a vanilla bond issue. It's not an allegation that this is a green bond issue and that there's greenwashing involved. It's not actually green. It's a bog standard vanilla sovereign bond, and the allegation is climate change is a material financial risk, therefore it needs to be disclosed.
It's really interesting, Sarah. I've heard that this has been labelled the first claim of its kind worldwide. You've called it unprecedented but not novel. Can you elaborate a little bit on that and maybe explain what the parallels might be for a corporate bond issuer?
Yeah, sure. It has been called the first claim of its kind because it is the first claim worldwide where a retail investor has alleged that investor statements are misleading on the grounds that climate-related risks are not disclosed. But it isn't a novel argument. For the last number of years, we have been tracking a series of claims in the US where municipalities, local governments, states and cities in the US have brought claims seeking billions of dollars worth of damages from what we call the carbon majors, which is this list of 90 high emitting companies who in aggregate are alleged to be responsible for 2/3 of the greenhouse gas emissions that have been emitted into the atmosphere during industrial times. This is an ongoing series of claims, some of which have survived motion to dismiss, where the municipalities are essentially alleging not that these companies were responsible for the emissions that caused climate change, but that they are either guilty of misleading disclosure type claims or negligence in tort for failing to warn, essentially, for promulgating what is alleged to have been misleading information to markets about the seriousness with which climate change may impact on municipal budgets. Really interesting, one of the claims relating to pre-trial discovery, it was actually one of these large oil companies that argued in response to the claim from some of the municipalities to say, well, if climate change is such a material financial risk for you and you're claiming billions of dollars worth of damages from us to fund the resilience building in your municipal infrastructure and to protect your communities, you would have actually disclosed that in your municipal bond disclosures, and you have not. So obviously it's not such a significant financial risk, or your bond disclosures are misleading. Really interesting argument, didn't go anywhere because that pre-trial discovery matter was not successful on standing grounds rather than anything else. But it's really quite interesting to see the way now that strategic litigants have picked up on that argument to say, okay, well, how are we going to apply that in furthering our cause, their cause, in relation to using the corporate law as a mechanism to drive action on climate change in what they see as the absence of policy movement on this front. How does it then translate into the private sector in terms of either its banks' own notes issues, say, or corporate notes issues where banks are assisting their clients and standing by them as they go through the issue process? The principles are exactly the same. The principles here are around the need to understand climate change as a material financial risk. and how it is potentially going to impact not only in a physical risk sense, but in the shorter to medium term, economic transition risks. Things like stranded asset risks, for example. Things like global policies in relation to pricing carbon, carbon border tariffs, for example, that have been proposed by Europe, etc., etc. The principle remains exactly the same around the need to be actively interrogating these issues, embedding them into your due diligence and verification processes, and certainly your disclosures in relation to those instruments. On that, Lloyd, I should say as well, one of the points that are often made here, particularly if the issues are going into wholesale markets, which obviously have lesser disclosure obligations than if you were issuing a retail prospectus per se. It's interesting though, because when we're looking at investor presentations and roadshows, even in wholesale markets, these are questions that are being asked by prospective investors. And so even if a position is taken that, well, we don't need to provide as much detail because this is just a wholesale issue, it's certainly from a commercial perspective a risk and opportunity that needs to be interrogated and prepared for, because investors are asking questions.
Very interesting. Now, the O'Donnell claim was only filed a matter of weeks ago, and we've yet to see what the Commonwealth's response is. But what's your view? Does this claim have legs?
It's hard to say, and I wouldn't want to make an observation either way, given that we're not advising any of the parties, but that we are certainly advising a number of our clients on the claim. But what does bear observation is this: it's filed by equity generation lawyers. Now, this is a public interest law firm, so to speak. It's actually a group of lawyers that were originally at Environmental Justice Australia, here in Australia. They're not a typical ambulance chasing plaintiff firm that are looking to make a buck out of a cut of the damages, so to speak. In fact, they're not even seeking damages with this claim. They're seeking declaratory and injunctive relief. They're funded very well out of Europe. So it's not a matter that, you know, from a strategic litigation point of view, you could think, okay, well, we're just going to throw as many interlocutory hurdles in their path until they run out of money. It won't work like that. As to whether this claim is itself strategic or they're intending to run it, we don't know, but it does bear note that they have form with two previous cases here in Australia. The first very much was a strategic claim against the Commonwealth Bank back in 2017, where they filed a claim on behalf of a shareholder alleging that the Commonwealth Bank's annual reports in 2016 were misleading, on the basis that the director's report did not identify climate change as a material financial risk. That was very strategic. It was filed a matter of weeks before the 2017 annual reports were due out, and in fact was withdrawn subsequently. But then in 2018, they filed a case against the trustees of Rest Super, which is one of the largest superannuation firms here in Australia, alleging that the trustees had breached their obligations under the Corporations Act to provide information to beneficiaries sufficient to allow them to make a decision about whether to keep their retirement nest eggs with the fund, essentially. And that was on the basis that when the beneficiary, who's the plaintiff in the case, had asked for information about, well, how do you take climate change into account when you're investing my money? The allegation is that that information was not forthcoming. And the secondary claim there is that, well, the reason it wasn't forthcoming is because it wasn't actually taken into account, which constitutes a breach of the trustee's duty of due care and diligence in maximising the benefits available to the beneficiaries. That remains on foot. that has actually been set down to run in November. So they've got form both ways in terms of running a flag up the flagpole, but also taking cases all the way to trial where they do believe that there is a valid claim.
You mentioned the funding. I'm curious to understand a little bit more about where is the money coming behind these plaintiffs, because I think O'Donnell and McVeigh essentially are students. And you mentioned that the funding is coming from Europe. Where's it coming from? What are the objectives? And is this a continuing trend that you might expect and that further cases may be taken in future?
Yeah, absolutely. There is a bucket of philanthropic money in Europe at the moment, looking to, and the US actually, North America more broadly, looking to fund these kinds of claims. I mean, not only that, we do keep our ear to the ground in terms of the thoughts of the plaintiff lawyers, the Slater and Gordons, the Morris Blackburns of the world. Here, those for-profit litigants, so to speak, so that we're able to advise our clients on, well, what's happening on the plaintiff front, what can we see coming? But putting that to one side, yes, there is a lot of significant six-figure philanthropic money coming out of Europe. One of the highest profile public interest litigation organisations over there, you might have heard of a public interest law firm called Client Earth. Now, Client Earth was actually originally funded by Coldplay, and at the moment, the majority of its funding is coming from one of the guitarists in Pink Floyd sold one of his guitars and raised £27 million for them. How do you get that gig? Not quite sure. But so you can see that particularly out of Europe, there is a lot of movement, a lot of recognition that whilst Europe itself is moving quite progressively in terms of policy action on climate change, in those jurisdictions where it has not yet, that being Australia and the US and Canada, the legal framework is actually ripe for these kinds of claims to be made through the courts.
Yeah, that's a very interesting topic you're moving on to that I'm keen to understand a little bit more about, which is, you know, these claims which are essentially alleging a misleading disclosure and breach of directors' duties. We haven't seen any of those particular types of claims in New Zealand yet, although I can talk a little bit more about that later. But why are they choosing Australia as the arena in which to fight these battles? Why is the European activist money seeking out an Australian courtroom? Yeah.
Well, first of all, as I say, there is a lot more central policy movement in Europe. The EU and the UK both have net zero by 2050 laws, for example. They have far higher benchmarks in terms of prudential regulation and disclosure in relation to climate change than we do over here. But not only that, our jurisdiction, Australia in particular, is very plaintiff friendly, and certainly on corporate law claims, the test for misleading disclosure doesn't require intent, unlike, for example, in the US with securities fraud. It's basically, is this likely to mislead or deceive? You don't even need to demonstrate damage. A. B, we do have a very active regulator who, unlike in other jurisdictions, is empowered to bring actions not only for misleading disclosure but for breach of directors' duties, which is not the case in many other jurisdictions, including the US, for example. We do have a very active and very well-funded litigation funding industry over here. And so all these factors are kind of lining up to make it a very attractive jurisdiction for those activist groups who are seeking to use the commercial law as a mechanism to achieve their aims.
But Australia is not the only place where claims are being taken, is it? These are issues. This is part of an international trend. Can you tell me a little bit about what's happening in other parts of the world that you're aware of?
Yeah, sure. And absolutely, it is part of a broader trend in terms of using the courts to achieve objectives where there is a concern that policy hasn't been able to do so. So in addition to Australia, if we're looking at misleading disclosure claims or claims against directors, we also have that series of cases in the US, more than a dozen now, on foot against the carbon majors, and in most cases, the directors of those companies, seeking billions of dollars in damages for essentially what is misleading disclosure. We have a case last year that was brought by Client Earth against the directors of a coal-fired power utility in Poland, where it was alleged that a decision to expand the capacity of a coal-fired power plant in Poland had been taken by the board without consideration of climate-related financial risks of carbon prices in the EU, and that therefore was a breach of their duty of due care and diligence. We've got claims on foot against both the company and the board in California, PG&E, which is Pacific Gas and Electric, alleging misleading disclosure in their annual report around the sophistication of their approach to backburning, essentially, around their transmission lines, which of course were found to be the cause of the camp wildfires that happened in California a couple of years ago, which is obviously top of mind at the moment. So there's cases all over the world. I could go on, but just in relation to directors' duties and misleading disclosure, they are many and varied.
Yeah, that's interesting. I'm just reflecting on what you've been saying and some of the things I've been reading, Sarah, about the way that we can think about these different types of climate-related litigation. And just reflecting on that, it seems to me, and let me know if you think I'm on the wrong track, that basically they fall into about 4 buckets. You first have got the disclosure cases, and I guess O'Donnell and McVeigh and Abrahams are great examples of those, which, as you've been explaining, whether they lead to a judgment or not are actually shifting behaviour. So CBA's annual report is now very clear about the climate risks that bank is subject to. And, you know, I'm thinking of advising banks here in New Zealand that they likewise need to be thinking about those issues with a lot of clarity. And I imagine any of our audience who are putting together due diligence checklists for a new offer will be making sure that they're asking questions of the issuer about whether they're adequately disclosing. Then we come to the governance type claims, which at least in my part of the world, we haven't seen any examples as yet, but are the kind of things that Noel Hutley's opinion, and indeed in New Zealand, the equivalent, which is partly based on it, the Aotearoa Circle opinion, are making really clear that directors and fund managers have duties to consider the financial impact, both physical and economic, of climate change. And I imagine that it will be just a matter of time before we start to see those claims will be shaped by the companies or corporations law in each jurisdiction. And some jurisdictions are more amenable to shareholders taking those claims directly against directors. Then I guess the next bucket that I was just thinking through as you were talking are claims typically against the entity itself for failure to mitigate. So claims against large emitters for causing emissions, or governments for failing to make sure that the emissions remain within boundaries. And here in New Zealand, we've seen an activist claim brought, which is called Smith against Fonterra. But it was also against 7 of New Zealand's largest emitters, people like Genesis Energy, New Zealand Steel, etc. And that was basically alleging in a very broad way that emissions were a breach of duties of care, negligence, public nuisance, or perhaps some new duty which has not yet been fully identified, and the first 2 claims got struck out at the Court of First Instance. The second is going on, being challenged by the corporates on appeal. But you know, that's exactly the kind of example where people are saying, well, I am being affected. And Mike Smith is a member of Maori iwi in Northland, and he's saying, well, as tangata whenua, we are being affected more than the general population because of our tribal lands near the water. But there's a lot of claims from the US, so that's the third bucket. And then I was thinking, there's also judicial review claims which essentially that some government agency didn't adequately have regard to climate risk. And we've seen a couple of those historically in New Zealand, but not actually yield a result. But I guess for any of our audience who are involved in project finance, for example, that's a risk that they need to be aware of, that permits that may have been granted for some activity, perhaps building a toll road, may have been granted at a time when a plaintiff might allege that the relevant agency didn't have adequate regard to the climate impact of that project. Do you think that's a fair taxonomy, a way of dividing up where these things fall, if you're trying to build your checklist of issues?
Oh, absolutely. I think that's a really useful way to put it. If you're looking for taxonomies beyond the commercial law as well, there's a couple of useful ones there that I could refer you to. With full disclosure, I was involved in writing both of them for the Commonwealth Climate and Law Initiative. We've just published a taxonomy of biodiversity-related litigation, which we've developed for some central banks in Europe who are starting themselves to look at the financial risks associated with biodiversity, so broadening out their focus from climate change. So if you would like to look at that, there's a copy on the Commonwealth Climate and Law Initiative website. And actually back in 2017, we initially did a taxonomy of claims associated with the transition to a low carbon economy for the European Commission, for the EU, which is available on the website of the 2 Degrees Investing Initiative. But going back to the 4 that you articulated, Lloyd, I think that last category is the one where we're seeing a real acceleration in claims in the past year, and actually the past few months in particular, particularly as more and more either countries or subnational jurisdictions are putting out there very explicitly their net zero emissions targets. And I know you have that in law there in New Zealand, net zero carbon, not methane, because we can't, you know, cows and sheep are far too important in New Zealand. Sorry, I couldn't get through without a, you know. But more and more countries around the world, including New Zealand, the UK, the EU, all have legislated net zero by 2050 targets, or legislated that into law. But not only that, many other sub-sovereigns here in Australia, every state and territory either has a law or aspirational target for net zero by 2050. And so now it seems like the administrative guidance around making decisions where climate change is a relevant consideration, either expressly or impliedly, because of either the physical or economic transition risks involved, the administrative guidance hasn't really kept up. And so a lot of decisions are being made where climate change is a relevant consideration, but in the absence of express direction to the administrative decision maker, hasn't been taken into account. So what we're seeing in the EU, the UK, and recently in the US actually is applications for judicial review of government approvals, things like the third runway at Heathrow, a number of other airports across the UK and in France in particular, the M5 motorway, and in the state of New York, a gas pipeline, where the allegation is, well, the approval decision was invalid and beyond power because the decision maker didn't expressly weigh up whether or not that project was consistent with the jurisdiction's net zero target. And so we've had a couple of the cases go either way. The M25 case that in the UK, it was upheld, the decision was upheld, but then cases like Bristol Airport, the one in France whose name I can't pronounce but it starts with L, and Heathrow's third runway, for example, and the Williams gas pipeline in the US, the decisions were found to be ultra vires because of the fact that the decision maker hadn't reconciled it against the net zero targets. So I think from a project finance perspective, it really does focus the mind on the need to be thinking about these issues up front. And even if you consider that they're not material, they don't warrant disclosure, at least be ready to be addressing them, because more and more we're seeing this kind of strategic litigation.
It's very interesting. I was talking to a friend of mine who's a leading QC here, and we were just talking about what has emerged as a little bit of a fashion here in the local authority world for the council itself to pass resolutions saying that they recognise there's a climate emergency, but then for the operational, parts of the council, the executive, to continue operating, approving activities in the usual way. And this friend of mine was saying, you know, that might be a great opportunity when I've got a little more time on my hands, because you've had the governing body of the council acknowledge that there's an emergency, which that very word implies a call to urgent action, and yet that's not translating into the way in which permits are granted or particular initiatives are being funded.
Yeah, there's actually parallels there between the administrative decision-making process and the obligations of due care and diligence. Neither of them are obliging a particular outcome, obliging a particular decision to be made. It's not that the duty of due care and diligence would oblige a bank board to say, right, okay, that's it, we're out of any fossil fuels. In fact, that would probably be a breach of their duty if they did so. These are obligations of robust process.
Yeah.
And at the moment, there seems to be an inconsistency between those statements of aspiration, those statements of concern, those statements of care, and then the detail and diligence with which the issue is then taken into account in the decision-making process, whether it's public sector or private sector.
Yeah, and it will be interesting to see as the financial reporting of the impact of climate risks develops, how that greater spotlight changes decision-making. Yes, it was yesterday that our Minister for Climate Change announced a proposal, which hasn't yet been translated into a legislative framework, where New Zealand is going to make mandatory TCFD-style reporting, although, to be fair, only for a limited category, mainly of financial sector entities. So, you know, registered banks, credit unions and building societies with more than $1 billion in assets, in New Zealand billion, managers of registered investment schemes, with greater than 1 billion of assets under management, licensed insurers with more than 1 billion assets, and certain Crown financial institutions with greater than $1 billion worth of assets. And interestingly, all NZX listed equity and debt issuers. But for those groups, I would think for those banks, which are New Zealand's big banks, if they hadn't already, they're going to be looking really hard at their loan books and reflecting on how that's going to be reflected in their mandatory climate reporting. The question I'm putting to you is, am I right to assume that's going to put a greater spotlight on the decision-making processes within our clients about how does this going to look when we come to report? And it's probably a couple of years before those reports start being published. So that's question one, number one. Number two, are similar steps being taken elsewhere in the world?
Yes. I must admit, I like the way that Minister Shaw is thinking, but my response to it was, I don't know what you call wet applause, maybe, for a couple of reasons. First of all, from my reading, and only my reading of his statement, was that the nature of the information sought to be disclosed is in relation to governance, strategy and mechanisms for risk management, aligning those categories with the Task Force for Climate-Related Financial Disclosures. There is no proposal on foot to make stress testing and scenario planning mandatory and to report in financial statements what your assumptions and variables are in relation to different climate-related financial risks, which is really the information that is decision useful for investors. There is already a requirement in 2020 on any organisation that is a member of or a signatory to the UNPRI, the Principles of Responsible Investment, and there's more than 95 trillion US worth of signatories there. So you'd think that a fair thwack of those institutions in New Zealand are already subject to a membership requirement to be reporting against those TCFD parameters. So the proposal that it be mandatory in New Zealand come 2023, I think was the earliest they said, was pretty safe, I think, for the Minister to announce, because it's nothing that most of them wouldn't be doing anyway. And put it this way, if you are waiting until 2023 as a large financial institution to do all this work, you are going to be slammed by investors well and truly in the interim. This issue is so dynamic, so fast moving. The bar of minimum expectation, let alone best practice, is getting higher and higher and higher. And I would guarantee that by 2023, compliance with the first 3 of the 4 heads of TCFD will not be sufficient to satisfy your obligations in relation to climate-related financial disclosures.
What's happening in Australia? Are there moves to make disclosure mandatory?
My view actually is that it is already mandatory. People talk about the TCFD as being voluntary. I call it volandatory, because if you think about from a disclosure point of view, as opposed to a management accounting point of view, your obligation is to disclose issues that are material to financial performance, financial position and financial prospects. How do you determine materiality in a disclosure context? It's what is decision useful for investors. Now, on the sole basis that there is now $45 trillion US worth of investors who've signed up to the Climate Action 100 Plus that are seeking disclosures in accordance with the TCFD of their investee companies, for that reason alone, you cannot deny that this issue is decision useful for a reasonable investor. It's not a fringe issue. In terms of specifics in Australia, we had changes to the regulatory guidance for both prospectuses and OFRs, operating and financial reviews, our version of the director's report in annual reports. ASIC updated its guidance on that in August last year to specifically refer to risks in the nature of those referred to by the TCFD. But more than that, we have had joint guidance from our Accounting Standards Board and our Auditing Standards Board last year that basically says, okay, everyone's doing all this great disclosure in the narrative portions of their annual reports about the risks associated with climate change. You also need to connect the dots to the financial statements, and particularly things like non-current assets that are valued at fair value, the impairments, the provision for bad and doubtful debts.
Yeah, IAS
you need
36.
to articulate. Yeah, you need to articulate how you have taken climate-related financial risks into account in arriving at those accounting estimates in your financial statements. We're into our second reporting season under that guidance. It is fair to say that the response has been pathetic in terms of adherence to the joint guidance. So it'll be interesting at the end of this reporting season to see whether ASIC and or the accounting standards bodies themselves actually start to express concern and agitate for reporting entities to increase their compliance, pull up their socks in terms of compliance with those instruments.
Yes, I was reading a little while ago about some of the major fund managers in Europe have actually been driven to writing to the big four audit firms, as well as particular companies, and saying that they are putting them on notice that the financial statements that they are producing are not accurately disclosing the climate impact, and in particular IAS 36, and the need to revalue assets which should have a different value given changes in circumstance since they were put in the books. Just as we're coming close to the end of our hour, and I want to leave a little time for anyone in the audience who wants to ask questions, I've got a final question for you before we go to those questions. Just for the audience, if you look at your toolbar, I think probably at the bottom of your screen, if it's the same as for me, you'll see a Q&A token. And if you click on that and want to type in any questions that you have for Sarah, please feel free to do that. But just while our audience are thinking about that, and Sarah, thinking about our membership in the BFSLA, who are both private firm practitioners and lawyers in-house in our large financial institutions. They've listened with interest to what you've been saying, but I can imagine they're now thinking, as they were at the end of the hour, go back to their day jobs, what are the key takeaways? What should they think about differently and maybe do differently tomorrow and in the coming months?
Of course, that's the how long is the piece of string question, Lloyd, and certainly understanding the breadth
Give us
of
three. Give us three.
It's like, oh, okay. Let me think about this. I'll give you four to try and cover off the audience.
Wow.
First, in relation to bond issues, notes, programs, all of that kind of stuff, and this is something that I've seen very much already in response to the O'Donnell claim. You really need to, as a lawyer, to start interrogating the business in terms of, well, how do you go about gathering information, verification, your due diligence procedures, and the disclosure checks and balances that we have in place in relation to climate-related financial risk is the first thing. Related to that, how do you go about due diligence in relation to the disclosures that are in your annual reports? Because your directors in particular will be asked to sign off on a hell of a lot more in terms of forward-looking information around the risks and opportunities associated with climate change. And so there is going to be that accordant uplift in expectation around the due diligence that's being done in order to support those disclosures. Third one, I suppose, related to that, with your directors and officers and your execs, having those obligations of due care and diligence, that inherently requires making sure that they have both a working knowledge of climate change, but an up-to-date working knowledge of the financial risks associated with climate change. And this is an area that is so dynamic that even we're finding annual briefings aren't sufficient to equip boards with the information that they need to understand the strategic implications for an institution. And then the last one, I suppose, if we're looking at things like credit origination and the way that internally an institution goes about assessing and pricing the financial risk associated with climate change, and how that is then reflected in risk assessments, interest rates, and their loan book. This isn't just something that should be done when the sustainable finance teams are looking at issuing green labelled products. It is a mainstream financial risk that needs to be taken into account, and not only just in that credit origination space, but then also looking at your existing portfolios and thinking about, well, how does that impact on default rates? How does that impact on the provisions we have for bad and doubtful debt, and whether any adjustments need to be made there? So I think that's 4 things. So your notes and bonds programs, your annual reports, your director capacity building, and credit origination and bad debts.
It's been fantastic, Sarah. The overall message that I'm drawing out of this is this is not really, I mean, there are indeed moral implications, and it is worth caring about polar bears and penguins. But as you're positioning the issue, this is a hardcore Excel spreadsheet challenge. And the question's not whether you, quote, believe in climate change and whether or believe it's anthropogenic. This is a realization that there are changes occurring in our environment and changes in our economies and in our legal frameworks. And they're going to impact on banks, insurers, fund managers, and the law firms that advise them, whether or not you sign up to like eating mung beans or wearing a caftan. And there's nothing wrong with that. But I think it's been fantastic the way you've really crystallized the importance of these issues for our audience. So with that, I'd like to, I don't see that there are any questions, so I'd like to say thank you very much.
I think Tanya's got her hand up there.
Oh, is there someone with their hand up? Can you see that? If you can see the question. I
can't see the question, but I can see a hand up. So Mike, I'm not sure, and Catherine Tapley's got her hand up as well. So Mike, I'm not sure if you can unmute.
Read those out, yeah.
Unmute
or if
the people
they're
with
able
hand
to
up.
type their questions in the Q&A bar that I referred to, then we can tackle those questions. Our administrator's asking us to unmute, so Tanya, go ahead. Catherine Tapley says that was an accident. Hannah Roberts
I was
said,
going to say, I would be surprised if Catherine Tapley has a question herself, being an expert in this area.
But Hannah Roberts says she's just wondering if there are any lessons here from the responses to other industries who've lost their social license and faced litigation. Asbestos, tobacco are a couple of examples.
Yeah, that's a really interesting question, and we're actually seeing oil, gas, and plastics as the new tobacco, so to speak. We're seeing young people in particular feeling like they don't want to work in those industries from a moral perspective. We're seeing increasingly institutional investors divest from those sectors or tilt away from those sectors, not just on moral grounds, responding to demands of their beneficiaries, but also on financial grounds, worried that these assets are going to be stranded in the transition to a low carbon economy. And certainly that is an analogy that is frequently drawn between oil and gas and tobacco from a strategic litigation point of view. The claims on foot in the US are very, very similar to those that happened 25 years ago. Odd now against the tobacco industry seeking damages for the health costs caused by tobacco.
Yeah, very interesting. Here in New Zealand, we're seeing actually the fund managers moving first because their retail mandates, 70% of funds offered in New Zealand now have some responsible investment criteria. And then you have the large institutional investors like New Zealand Superannuation Fund and ACC being very clear that they are taking climate issues into account, essentially because they are concerned about the issues, but also they think that the market has not yet fully priced in the risk. And, I imagine you're seeing the same in Australia.
Yeah, absolutely, absolutely. I mean, we're seeing it all around the world, even in the Northern Hemisphere. Annual reporting season just gone. We had shareholder resolutions filed at Barclays, at JP Morgan, seeking the companies to put in place net zero financed emissions policies and roadmaps over the short and medium term with which to get there. So we're very much seeing the large asset owners driving this. As of tomorrow, here in Australia, 4 out of the largest 6 of our superannuation funds will have net zero portfolio targets for 2050. So if you think about the scale of that shift and how if the money on the equity side is shifting very, very quickly, how that is then going to translate into higher default risks from a debt perspective over the shorter term, it is a very, very real issue.
We've got one final question that I'll put to you, Sarah, and then we need to wrap up because I'm keen that we do close on the hour. So Rebecca asks, one of the reservations that companies indicate that they have about making forward-looking statements about the effect of climate risk is potential liability if they get those statements wrong. Do you have any views or comments on that concern? Absolutely. That is one of the most common questions, certainly I get asked by boards. I think that is driven by a bit of a misapprehension about, well, firstly, what the misleading disclosure provisions say, and secondly, what the function of stress testing and scenario analysis on a forward-looking basis is. So on that first point, if you're making disclosures in relation to prospective risks, forward-looking risks, you need to have objective, reasonable bases on which to base those projections at the time that they're made. Now, if there is one thing that is unreasonable and totally outside the plausible bounds in relation to climate change, is that the future will bear any resemblance to the past. So by remaining silent about the risks and opportunities associated with climate change, you are actually representing that you do not believe it's a material risk issue for you, which is the only thing that we know, which is that it is a material risk for financial institutions. Secondly, misapprehending the role of stress testing and scenario planning. It's not an exercise in prediction about what you think is likely to happen because of the fact there are so many variables at play.
it's basically taking that plausible range of climate futures and demonstrating to investors that you have considered across that plausible range what the implications might be. So, you know, one end of the spectrum, everyone complies with their Paris Agreement targets, decarbonises the global economy before 2050. That might minimise physical risks associated with climate change. And so, for example, lower impacts in your agriculture portfolio, for example, ag lending, but bakes in a hell of a lot of economic transition risk because it presupposes that there will be no coal-fired power, total conversion of transport across to electric vehicles, all that kind of thing. What does that look like for your portfolio? Other end of the spectrum, business as usual and climate change, bakes in 4 degrees of warming by the end of the century. Yeah. What does that mean for your portfolio? Well, the answer is doesn't really matter. Throw your papers up in the air because no one will be making money.
And there is also the risk, isn't there, that businesses are caught in a pincer with the transitional changes occurring, but still us falling short of the 1.5% target. That's been fantastic, Sarah. I've really appreciated you making time to talk to our members. We're delighted to have you here, and thank you very much. To all of those who attended, thank you very much for making the time. I hope that you've got something useful out of this, and we'd certainly appreciate any feedback or comments that you have for the association about how we can continue to make ourselves relevant to you as our members in these extraordinary times. So thank you very much to you, Sarah, and thanks to our audience.
Pleasure.
Good afternoon.
Bye.